5 where they are applicable as laws of Kenya.
Have you had occasion to apply anything?
Not really, I haven't applied anything, but I have come across authorities and past decisions where this has been applied. Yes.
Any that comes to mind?
I know that the International Convention on Civil and Political Rights has been applied by the Supreme Court, and I am aware that the International Convention, the children's rights also has been applied in quite many cases.
Okay.
Yes.
I want to hear your views regarding a recent decision by a high court sitting in Mombasa, whereby the judge declared the section 8(2) of the Sexual Offences Act as being contrary to Article 28 and 51 of the Constitution.
Thank you, Honorable Chief Justice. I am aware that the issue of Section 8 of the Sexual Offences Act has been a debate, and especially after the decision of the Muruatetu case. Because after the decision of the Muruatetu case, many courts interpreted that decision as applicable on the issue of mandatory minimum sentences. But later, the Supreme Court in the Muruatetu case number 2, the second one, where they give directions, that was stopped. But I know the court gave room for parties to bring that issue before the High Court so that it could go through the process. And the courts have now made a determination that Section 8, as regards to mandatory minimum sentences, it contravenes the provision of the Constitution. And I agree, because reading through the decision of the Muruatetu, the court dealt with the issue of fettering the discretion of the judges and the magistrates on the issue of sentences.
Thank you. The next set of questions will be asked by Commissioner Macharia.
Okay, thank you, Honorable CJ. I'll ask you just 2 short questions.
Yes.
Much of what I wanted to cover has been covered by the Honorable CJ. The first one is, in your long career, what would you consider to have been the most challenging event that you faced as you discharged your duty, and how did you resolve it?
Thank you, Commissioner. Looking at my career, I think the most challenging event is where the parties before me became very antagonistic. I have an example, a matter I handled in Machakos, immediately I reported there. It's a matter that was very volatile. The parties, the advocates, the ODPP office were so antagonistic in the matter. And when I got there, it's one of the sample writings I've put there. When I got there, I looked through the file and I realized all judicial officers had recused themselves from handling the matter because of the heat. So as the head of session, I had to put my foot down. The matter had taken almost 8 years in the process, and I decided to put my foot down, hear the matter, and make a determination. The challenge that matter is that the parties moved to the High Court twice, challenging some of the rulings I had made and seeking my recusal, which I had declined. But the court agreed with me that that matter had come to an end. I think that's the most challenging matter I've handled.
Okay.
Thank you.
Now, secondly, and this is my last question, is on matters accountability.
Yes.
Now, what do you think has been the most challenging part of holding judicial officers to account? And in answering that, how do you think these issues of accountability, what are the most important principles or attributes that should be applied by judicial officers so that the public can have confidence in the institution of the judiciary?
Thank you, Honorable Commissioner. I think the challenge of the issues of integrity in the judiciary is a serious issue, and this issue is mostly a perception issue. And I think the biggest challenge is that we have been a bit closed. I think we have not communicated to the parties who come before us, to the advocates. I have, when in my early years in the judiciary, I would deal with the parties, and later I would hear parties were asking, what did the court say? They would go back to the custody and they didn't know what the court said. In fact, the colleagues from the other side took advantage. They would come and make an application quietly there, get an adjournment probably, and then when they go out, they tell the parties, the court says they are not ready to hear the matter, or they have adjourned the matter. So I think we have a responsibility, and this is something I've taken up, to communicate to the people who come before us. Tell them what is happening, tell me what the court has decided. If it is a sentence, the person being sentenced should know the sentence that has faced him. If there are parties, if a matter is being adjourned, all the, because the issue of perception is a serious issue in the judiciary. Yes.
Yes, thank you. Justice Wasame.
Thank you very much. Your Honor, let's continue with that debate raised by the Honorable Chief Justice, and which was also discussed with you by the Vice Chair, about the decision by the judge which made section 8, 2, 3, and 4 unconstitutional. And you said you agree with that decision. My understanding, and you know, there are two types of judges. One are those who merely interpret the law as is, and secondly, those with some sort of agenda who create law through legislation from the bench. And we all know there are three arms of government. Legislation is primarily left for the legislators. Here is a judge or a judicial officer saying an act of parliament which had specific sentencing provisions unconstitutional. What is your view?
Thank you, my lord, for that question. Looking at that decision, it is not from nowhere, because it has flowed from the Constitution, and the court has a duty.
Which provision of the Constitution?
Article 51.
Yes.
Right to fair trial, and Article 27, I think.
Yes.
And the court has a duty to align the law to the Constitution. I think that's a duty, cardinal duty for the court.
So what is the problem here with
The
the
problem
Sexual
here is
Offences
that
Act?
where the law provides a mandatory minimum sentence, the parties, even those who have been sentenced, or even if they mitigated.
Why is that the role of a judge? Creating law is for parliament. The role of a judge is to interpret the law.
My view, my lord, is that.
Yes, and even during the time we were making our constitution, nothing was questioned about. There are many provisions under the Penal Code and the Wildlife and the Narcotic Substance Act, which have mandatory and minimum sentence. Why is it the role of a judge to say, this one I don't agree because of A, B, C, D? What is the role of parliament? And now, why are you putting words into the mouth of the Supreme Court? Because the Supreme Court did not, from my reading of the first one and the second one.
Yes.
Yes. They did not say the mandatory and minimum sentences are unconstitutional.
Thank you,
unless you have read a different text.
Thank you, my lord. Yes. I think law is a growing. Law is not static; it grows, and that's why the courts have a duty to interpret the law. And it's in many jurisdictions that law continues to be interpreted to align with the provisions of the Constitution. That's my view, that the interpretation by the judge is meant to align the law in that act with the Constitution, which is paramount.
So in
and
your
which is-
view, any provision in our penal code or in our acts
Yes.
which have mandatory or minimum sentence is unconstitutional?
I think from the decision in Muruatetu, the Supreme Court said if those matters are taken to the High Court, the High Court has a duty
I'm
to
asking
decide.
about your opinion, because now you'll be a
My
High Court
opinion
judge,
would
yes.
follow that decision, that mandatory sentences that fetter the discretion of a judicial officer or a judge is unconstitutional.
So it is your view that Parliament has no role in determining a particular provision, saying that this is the minimum sentence and this is the mandatory sentence. That's your view.
It's not my view about Parliament, because Parliament is an independent institution. If they decide it comes to court, the court has a duty to decide, and that's what the court is doing. It's saying, according to us, as the court has to interpret the Constitution, these provisions that you have passed are contrary to the Constitution.
Now, flowing from that,
Yes,
the Anti-Corruption and the Economic Crimes Act
yes.
has a specific sentences. If you are given the opportunity today to deal with a sentencing matter involving that act, you will not impose the sentence provided for, which is mandatory. That's your view.
I'd look at the act, see how
I am
how
telling you that I have looked at the act. It
Yes.
has mandatory
If
sentence.
it has mandatory sentence, I look at it vis-a-vis the decisions of the High Court and the Supreme Court and the Court of Appeal, and I'll make a determination.
So I want you to make a determination.
I would make a determination that mandatory sentence would be unconstitutional.
Would be
As held,
unconstitutional.
yes.
Okay. Thank you very much. I wish you well, Your Honor.
Thank you.
Thank you, Commissioner Majanja.
Sorry. Can you tell us the difference between summary judgment and striking out of a pleading?
The difference between some
And striking out.
Thank you. My understanding of summary judgment is where a party has come to court seeking liquidated claim. Once the other party does not enter appearance and file a defense, a summary judgment will be entered. It will be a final judgment. Yes. Striking, the other issue was about striking a suit. Kaidre, can repeat that?
Yes,
other part?
I was asking for the difference between
Yes.
summary judgment and striking out of a suit. Entering summary judgment and
Yes.
striking out.
So this one is different because the suit in striking out, the merit of it is not considered. Yes.
And what about the principles applicable in both instances? Is there a difference in the principles applicable?
Thank you, my lord. I would need to look at that.
Okay.
I don't want to over.
Okay. Companies Act 2015 brought several developments to the old Companies Act.
Yes.
We knew and we were taught by the late Justice Njagi. One of the developments was, for example, a company can now have one shareholder. Any other developments?
I think there's also a development that a private company which has less than 5 million of capital share need not.
Okay, any other?
I can't put my finger on any other.
And how does the the new Companies Act relate to the law of insolvency? Any relationship?
My lord, thank you for the question, but I admit I
Okay.
haven't.
Okay.
Yes, yeah.
Okay. Now, what is your favorite area of adjudication? You adjudicate over many disputes. Tell me which is your favorite area. Criminal law.
Yes.
Okay. Maybe you can tell this commission, when you have had, when an accused comes to court for plea, okay, what are some of the red flags or alarm bells you look for? Because as a judge, you learn to your environment, your cases. So when you're taking plea, what are some of the red flags you look for as you're taking plea?
Thank you, my lord.
Give us three.
Some of the red flags I look for is the state of the accused person presented to me. Some of them come when they are injured.
When they're
they've
injured.
been assaulted.
So if they are injured, what do you do?
So I will refer him back to the police to be taken to hospital first to receive treatment before he takes plea.
Second?
Second one, I'll also need to observe from my view the age of the accused person, because sometimes we have ended up taking plea for minors and convicting.
So if you are in doubt, then what?
So if you're in doubt, then I will inquire from the accused, and if I'm still in doubt, I'll request for an age assessment.
And third one?
The third one, which I can put my finger on, is probably I'll need to look at the charge sheet and see the length of time the suspect brought to me has been in custody.
Okay.
Yes.
Thank you. Thank you very much, and wish you well. Thank you.
Commissioner Gutia.
Thank you, Chair. Good afternoon once more, Your Honor.
Good afternoon, Commissioner, and thank you.
Okay. There is this saying that when a person leaves the court, if they have lost or they have won, they need to feel valued. Do you believe in that?
Totally.
And what are some of the things as a judicial officer or a judge you ought to do to make sure that persons who come to your court feel as though their case has been handled in a just manner?
Thank you, Commissioner. I think the first duty as a judicial officer is to ensure that I handle all parties that come before me impartially from the beginning of the matter, and that I ensure that they understand what we are going through. So if it's hearing, if it is, I need to want to know whether they understand. If they don't understand the language, we need to get an interpreter so that they also take part fully in the process. And then ultimately at the end of the decision, I need to explain to the parties the reasons, analyze the evidence, give them the reasons why I have come to that determination. And I believe if they understand why, then they will go out saying, though we didn't win, we know why we lost.
Okay. So I'm making reference to one of the sample writings that you shared, that is in the case of R versus someone, I can't remember the second name. It's a case on fraud, and part of the allegation was that someone lost about 16 million shillings, a land transfer gone bad. And in your judgment, you did take note, because it's a matter that had taken quite long to conclude, and in your judgment, you did blame both parties for the delay. You ultimately, based on the evidence presented, you ultimately found that the prosecution had failed to prove their case. But a statement which I found, if I'm the complainant in that case, I would put some question mark in your decision. This is what you said, that the accused persons can ultimately take a break. They are all acquitted of all the charges facing them under section 215 of the CPC. The words that you use, you have a complainant, you have the accused persons. Yes, you have established that the prosecution had failed to prove their case, but the wording you use, do you think the person who lost, and I'm talking about somebody who has lost about 16 million, though you have stated there was no proper evidence, what would that person have felt leaving the court, the complainant in this case, when you say accused persons, you can take arrest?
Thank you, Commissioner. I think my words are not from nowhere, because I had built the reasons why we are coming to that point. I had given the history of the matter and what the court had gone through in handling the matter. And as you say correctly, I laid the blame on both sides because from my observation, when they carried themselves before me, they participated in delaying this matter. But the court, I think the accused persons carried a greater weight. Most of them had been in custody for long. I think one of the accused persons had been interdicted from a job for over 10 years. In fact, he was about to retire. And so I felt that their day had come, and I needed to say that.
Okay.
I don't know
And
how it would have been interpreted, but I
do
wouldn't
you
think-
agree with me that a complainant who feels as though they have lost some money, because you know the burden of proof in criminal and civil are different, that statement
Thank
may
you, Commissioner. My view is that a party who understood where we had come from, I don't think they would, unless they would not take offense with that statement.
Okay. While you're interpreting the law, what articles of the Constitution guides you?
While interpreting the law,
Laws generally,
Yes.
when matters come before you and you need to interpret statute, what principles or what articles of the Constitution guides you, or you don't think it is necessary to use the Constitution in your work?
Thank you, Commissioner. It is very necessary to use the Constitution. I think Article 159, Article 2, Article 259, Article 50, all those articles have bearings in matters which come before me.
Okay, thank you very much. And I've received a comment from Machakos Law Society, and they say that you do a good job. So wishing you the very best.
Thank you, Commissioner.
Commissioner Gishoi.
Thank you, Madam Chair. Good afternoon once again.
Good afternoon, Commissioner.
Yeah, just before I go to my one or two my questions, when you complete a file in court and you finished with it completely, what directions do you give about that file? Is it made available to the public to look at?
During my time in Machakos, I had to encourage my colleagues to type their judgments. And I am glad and proud to say that all the JUs in Machakos type their judgments. And therefore, when we deliver judgments and rulings, we tell the parties that the judgments and rulings are available on request, because they have to pay some fees for that. So any party who wants a decision we have made, it is available almost immediately.
So excuse me, just in case I'm not looking at your right direction, did you have any occasion to have to order that the file be locked, be kept in a lock, key, a locked?
Yes, I did.
Why?
Because that file, in fact, it had been under lock and key for all the, because documents had been lost. If you go through the file, you realize exhibits had been lost, pleadings had been interfered with, and those issues had moved to the High Court. So I still thought, because the matter was still pending, and maybe any party would have wanted to go for appeal, it was important to preserve that file. Yeah.
Okay, thank you. The other was accommodation. I've seen that in 2017, your court was declared the best overall in case in backlog clearance, in 2017, Machakos.
Yes.
Would you share with this commission the strategies that you used to ensure that you achieve that goal as
Thank
the
you.
best overall court?
Thank you, my Lord, my Honorable Commissioner. Our strategies where I have worked is first to understand what we have. So we do auditing, regular auditing of all files to understand what we have. And then we capture the files according to their ages.
So in case you get this job as a judge of the High Court,
Yes.
how are you going to apply the same skill or the same strategy? How?
Honorable Commissioner, I'll apply the same strategy by bringing the teams who will work at me together, involving the stakeholders to understand why we need to clear with the old matters, and also do my part as a leader in that aspect.
Okay. Finally, it's about this curriculum on active case management. How far have you gone in the development of that curriculum?
The last time we had a meeting, we were doing a curriculum on virtual training because of the challenges we had during the COVID. We had done some virtual trainings, but we realized that we needed experts to develop a curriculum on virtual training because of the challenges we had faced as we trained virtually during
Okay.
COVID.
Thank you, Chair. Thank you, Mheshimiwa.
Thank you. Professor Mugen.
Thank you, Chief Justice. I was just reading something, Your Honor, which says that emotional intelligence, yeah, within the context of law, and in this particular article is in connection with the international criminal law, can be a positive and a good judicial resource. That's what they say. And so, and in fact, they continue to say that it can also be a great promise for the administration of justice. And they have even gone on to say that in ICC, they are now training their judicial officers in emotional intelligence. So my question is, do you agree that is a resource, and if so, why?
Thank you, Honorable Commissioner. I totally agree about the necessity of training judicial officers and judges on the issue of emotional intelligence, especially in a criminal court. Commissioner, most of the matters handled in the criminal court are very demanding emotionally. And I know when I started my work as a judicial officer, some of these cases would have a very powerful impact on my emotions. So with the time, of course, I have learned to manage my emotions. I'm very level-headed. I'm very calm. I'm able to take issues and dissociate myself with the emotions of the parties. But I think it's a challenge for many judicial officers that some of the issues that come up during criminal trials can be very, very challenging in emotional management.
So just a bit of follow-up on that one, Your Honor. There are also people who are feeling very strongly that judicial cognitive process, you know, the reasoning and all that, might be unconsciously impacted by emotional intelligence. So do you think judges can sometimes, their judgment can be affected by emotions even as they use cognitive process to decide on judgment?
Thank you, Commissioner. From my own view, I think for those who are starting a career in the judiciary, it would be a serious challenge. But I have had interactions with judges who have been in the bench for years and magistrates. With the time, one is able to manage these emotional challenges that come with the matters that come before us. And we are doing a lot of mentoring to our junior colleagues, how to manage this. Of course, we do our internal, I would call them training, because we talk to our judicial officers how they need to dissociate themselves with the emotional issues in court. It is a challenge for somebody who is coming in as from the onset. Mm-hmm. But with the time, I think we learn to get a thick skin and manage our issues.
Okay, would you describe yourself, Your Honor, as an innovative leader? And if so, where you have headed stations?
Yes.
Are there some innovative things that you have done that you can tell us about?
Thank you, Honorable Commissioner. An example I can give maybe is on the issue that we were dealing with of emotions and management of staff. What we did in Machakos is that we formed a committee which we call, not really a committee, but a team we called Council of Elders, to deal with our staff who had serious issues, drug, alcoholism, social issues, and it has really helped most of our staff. I think that, for me, even as a manager, it was very helpful.
Who are the members of Council of Elders?
The staff members, elect members whom they think they can approach and raise their issues with confidence. Yes.
I've not heard of that, but I think that's a good innovation. If it has worked for Machakos.
It has worked.
Okay.
Yes.
Thank you, CJ.
Thank you. Commissioner Rwanda.
Thank you, CJ. Good afternoon once again.
Good afternoon, Your Honor.
Okay, I want to ask you about bail and bond. What are the factors you consider when reviewing bond terms? When reviewing, not granting, but reviewing bond terms.
When reviewing bond terms. Thank you, Commissioner. When reviewing bond terms, we consider the offense first, and the parties, the accused persons who come before us. And the reviewing bond terms is the parties will apply, either through the advocates or when they are in prison, they write letters and apply saying, I cannot raise the bonds, the terms of bond that have been set. Can I be considered? So we consider all those factors and we review bond terms.
So
It's a regular practice.
to hear you, I mean, if I heard you correctly, you are saying that you consider the accused person when they have written or appeared and say they can't raise the bond terms,
Yes,
and also you consider the offense.
yes.
Do you consider the views of the victim or the complainant, for that matter?
Where there is a complainant, that is because the main complainant is the state.
I was about to tell you there is no
Yes.
criminal case without a complainant. Yes.
So whether it's a complainant, then we listen to the prosecution. If they have any objection,
You
they
consider
have
their
it-
views.
They consider their views and we put them down.
Okay.
Yes.
So in determining whether the accused person really can't raise the bond terms earlier fixed, how do you go about that?
Of course, it's an issue can't weigh because the court has no capacity to investigate. But we listen to them.
You go by
They
instinct.
write to them. You also go by, because you look at them, you can see how they appear before you. You are also able to assess how they have come, and you are able to at least give some reasonable terms.
Okay.
Yes.
So now, my colleague and brother, Commissioner Judge Majanja, had asked you about red flags. I want to give you a scenario and tell me if that would raise a red flag for you. Parties appear before you, or an accused person is charged before you. You give them bond terms today. Tomorrow, you review the bond terms to less than half what you had earlier granted. Is that a red flag for you?
It will depend on the circumstances. I'll need to look at the circumstances. Under what
Okay.
circumstances were they reviewed? What were presented before me? Probably an advocate came and gave the history of the person, their economic status, where they come from. In some areas where I've worked, they are not title deeds. People have land, but they are not title deeds. So if you are strictly fixed on title deeds, nobody will leave prison on bond. So we give all those considerations.
I'm just wondering if, in your view, the time between when the first bond terms were fixed and the review that has been done has any bearing on the ability or inability to meet the bond terms?
Not much, Commissioner, because sometimes we take plea and an accused person goes back to the remand and is advised at that point, ask the court, ask the court to review your terms, and they leave a letter handwritten which comes before you, and they are saying the terms you have given me, I will remain in custody for how long, I can't raise them. And then you mention the matter with the prosecution, ask them whether they have issues. We look at the person, is he able to avail? If he gets a surety, then I would reluctantly want to use that to deny that constitutional right to an accused person.
In your judicial practice, how often does that happen?
It's not common. It's not. I don't say it's a common thing. It's not very common.
Okay.
Yes.
Maybe we'll get back to that. I've looked at your performance. Indeed, like you said, I think you did quite a good job in Machakos. I'm hoping wherever you are, you'll replicate what you have done. There is no backlog over 3 years in Machakos. Your backlog for over 1 year is 660 as against a total caseload of 7,157. That still shows that you are really working on, essentially working on current matters, which is commendable. Your case clearance rate is 80% as against 83% of the national average, and your productivity is 346 against 526. Now this is of concern to me. You have no backlog. You're really working on clearing your backlog that is 1 year old. You have no backlog that is 3 years old, but your case clearance rate is 80 against 83, productivity 346 against 529. just to get whether you appreciate the parameters on which you are assessed. Why do you think this will be an issue of concern?
Thank you, Commissioner. I looked at it and I didn't exactly get why we at that level. I didn't want to look at the depot and think, but I appreciate the work they are doing.
It's an issue of concern.
What my view is that when you are dealing with newer matters, they will take long to conclude, because they, of course, with the pre-trials and all those before the preliminaries are done and you start hearing. So if you have older matters, you may be able to fast track them, because most of them have started. Some witnesses have testified, and some are at a very advanced stage. So it is possible to clear as many matters when you have matters that have. But,
Okay.
Yes.
What I was looking to, why it's an issue of concern to me mostly, is because this is an indication that you will be creating backlog very soon again. Because if you are not, you understand how case clearance
Yeah,
rate
I
works,
understand,
isn't
I
it?
understand, yes.
Yeah, if you are not at least at 100, better if you are over 100, but if you are not at least at 100, it means in the next evaluation, you'll probably be having backlog again. That's why I'm saying it's an issue of concern.
I see your point, Commissioner.
Okay.
Thank you, thank you.
Again, on the issue of corruption prevalence, it's high in Machakos, 8.4%, 8.47%, as against the national average of 7.03. I don't know what interventions you are putting in place
Thank you, Commissioner.
to address this, because I noticed this is in 2019, but you left very recently. So what interventions have you put in place?
The first intervention, as I said, is communication. Ensure that we communicate to all people who come. In fact, it is we make it a point to inform our customers that no cash is received in the courts. All monies are paid through the systems, and that has helped. And that money is not given to anybody. We realized in Machakos when I went there were so many brokers along the corridors. And that is an issue we have dealt with. We have also taken it to deal with our staff, keep them abreast that any involvement in integrity issues will not be entertained.
Okay.
We have taken steps in some of the issues that have come up, and I think we have taken. I really want to see the returns for this period now.
I'm
Whether
also
we'll still
equally
be there.
hopeful.
I
I'm
hope-
also
I hope
equally
we
hopeful.
have done much better.
Okay.
Thank you.
I've looked at your application. Your documents are in order, save that the report you received from KRA is that you have not been cleared, you're not compliant. I believe you must have been informed. I don't know if you've resolved the issue.
Yes, Commissioner, I saw that. I saw the communication from the JSC. I think what KRI did not inform the JSC is that I have moved to court because of what they put me in on charges. They were demanding some taxes that I am certain I do not owe.
Oh, so you are litigating on this
So there's
matter?
a matter, but when I got a letter from the JSC asking me to see them. I saw them last week. I am glad to say that they gave me an audience, and we have started an ADR. We
Okay.
are going to resolve that matter
Okay.
soonest, yes.
Okay. I hope you do. Otherwise, the report we are getting on you, just like my sister Commissioner Ngutia has mentioned, is that you have good communication skills, you are good in administration, you handled your colleagues, you give them leadership. Apparently there is a colleague you worked with at some point who was delaying judgments, but you are able to intervene, and there was improvement in that area, and they commended you for that. You have good temperament and control of the court, you are patient. And I think this is a report we are getting in reference to the matter you said was most challenging to you, where advocates apparently want to come to blows, and you managed to handle the situation quite well. So you come highly recommended. I wish you well.
Thank you very much, Commissioner.
Thank you, my lady.
Yes, thank you very much, Honorable Kibiru, for that interaction. I think this brings us to the end of the interview. But before we end, I'll give you an opportunity to ask us any question if you have any.
Thank you, Honorable Chief Justice, for the opportunity. I do not have any question to the Commission. I just want to say I'm very grateful for the second time to appear for such an interview, and I pray and hope that this time round I will be positively considered.
Yes,
Thank
on
you very
behalf of
much.
the Commission, I wish you well. We will be in touch with you when we complete the process.
Thank you, Honorable
Keep up the
Judge.
good work in Nyeri now.
Yes, I'm in Nyeri now.
Okay, all the
Thank you.
best.
Thank you, Judge.
Mm.